My topic is how to raise or to elevate a regional problem, meaning a crime, to a global problem, first, and second, how to deliver universal or universalist justice while not neglecting the regional dimensions of the alleged crimes. My task is then to illustrate this double tension and examine how the international criminal justice system and the ICC in particular have addressed this double tension. I will first contextualize. I will, from the outset, underline, it will be obvious to you, that many of the problems, especially for the ones who are in the judiciary, many of the problems I will present are problems which also appear before domestic courts. Most of them have nothing specific. Simply the context is specific to the international criminal justice system. I will not address the question and the rivalry between so-called common law and so-called civil law systems. Some scholars tag this question within the general question of multiculturalism. Why not? Because tags are questions of sensibility. But these operations completely eliminate the discussion on the clash of civilization and the Western domination in the field of international criminal justice. Therefore, it's politically tainted. But it allows me to make one difference which is important in this auditorium and with this audience, the difference between culture and legal culture, which has not been addressed until now, it seems to me. With the clash between civil law and common law, you see clashes between legal cultures, but you don't see really clashes between cultures. And I will come back to this point when I will briefly comment on my experience in international criminal justice. Neither will I directly open the hot debate on the ICC as an African court, quote unquote. It's a fact, naturally, that all judgments to this day of the ICC concern Africa, and most of the prosecutions, not all, concern also Africa. But this is more a question about prosecution and prosecutorial policies than the question I have identified as the question of multiculturalism in my first part. The relevant question being how do universal justice take into account the regional sensibilities. I will choose another starting point, a simple observation. 2/3 of humanity are not participating in the ICC, in the International Criminal Court. In those non-participating countries, these countries are subject to the jurisdiction of the ICC when they act on the territory of a country which is party to the ICC, but let's leave it aside. So in these non-participating countries, probably in this room, most people think immediately of the US and Israel, but this doesn't bring anything about multiculturalism, to the opposite. What I have in mind are India and China, which really represent 2/3 of humanity, which are not parties to the ICC statute, and have not, unlike the US and Israel, especially the obsession of Mr. Bolton with the ICC, which is something which probably is for physicians more than for jurists. But unlike Israel and the US, they are seen not to be interested in the system. And this quasi-absence is one of the main factors why international criminal justice has not really succeeded of departing from its Western origin. It's a truism, but it's a very often repeated truism that, I quote one of the main scholars in the field, Western justice modalities are not value neutral, for sure. Some critics of the international criminal justice system go a little bit further, or go further, especially those who belong or are familiar with the so-called third world approaches to international law, which I think have not been mentioned here, but which are important in a multiculturalist discussion, the so-called TWAIL group, or TWAIL approach. And these scholars go beyond this simple observation that Western justice values are not universal. And I quote again one of the representatives of the TWAIL approaches, I quote, ICC does not represent justice in and of itself. It represents the shifting of the locus of the real by choreographing processes within which new norms of justice making are reinforcing. So the task of the ICC, according to this very critical approach of the international criminal justice system, is to choreograph, to make the choreography of the shifting from the local to the global. For those scholars and those who are attentive to the questionings, the question is how to integrate non-Western values and build a balanced model of justice which does not simply reproduce in new terms the domination of Western powers and incorporate the plurality of cultures and values. The system, and when I speak about the system, is the international criminal justice system, of which naturally the ICC is an important part, but not the only component. The system has certainly made efforts to integrate cultural differences. However, these efforts, firstly, have not been as serious, focused, and continuing as they should have been, in my view. One example, for instance, is the hearings before the Special Court for Sierra Leone, so not the ICC, Special Court for Sierra Leone, about the very famous child soldiers issues in 2003. If you go through these hearings, which have been very long, for 6 months, if I remember well, you don't have 1 minute dedicated to a discussion on local culture and local beliefs. Second point, or second critic, the treatment of cultural differences has been sometimes tainted with arrogance. Listen, for instance, to the excerpt of the trial chamber in the trial chamber of the International Criminal Tribunal for Rwanda. In its first decision, Akayesu, the very famous Akayesu decision, the trial chamber had to verify the credibility of witnesses. And I put only a small excerpt, but I will read further what they wrote in the final decision. The first quote is, "It is a particular feature of the Rwandan culture that people are not always direct in answering questions, especially if the question is delicate." It's interesting because it's fake multiculturalism, because you could see exactly the same for a Swiss, German, or Israeli witness. But it continues. The chamber also noted the inexperience of witnesses with maps, films, and graphic representations of localities, which reminds us a lot about the first anthropologists who found out that in Eastern Pacific, the populations were less familiar and less comfortable with mathematics than in the West. It's a little bit the same. It goes on, in the light of this understanding, the chamber did not draw any adverse conclusions regarding the credibility of witnesses based only on their reticence and their sometimes courteous responses to questions, which is really arrogant in my view, and it should not be drafted that way. You know, this is really a Western view, by non-Western partly, on this culture which are a little bit circuitous. Nevertheless, we will see that some steps have been taken in order to globalize the approach of the international criminal justice and integrate plurality in its treatment of crimes. I mentioned earlier the absence of India and China among the parties to the ICC. This does not mean an absence of interest. China is classically worried about the activity or activism of international criminal justice and the danger, the possibility of endangering stability, both regional stability and international stability. India is more focused on cultural differences, and especially the critic of the ICY, the International Criminal Tribunal for Yugoslavia, at the beginning is interesting. They underlined, the ambassador to the UN, and they underlined that these tribunals are detached from the economic and social realities, and they are ill-informed on these realities, as no judge coming from the concerned countries, ex-Yugoslavia or Rwanda, sit within the tribunal. The establishment of so-called mixed tribunals, with which I worked for a couple of years, may be kind of re-establish a kind of balance, because in the mixed tribunal you have judges and legal officers coming from the concerned country. In the Special Tribunal for Lebanon, where we had Lebanese colleagues and Lebanese legal officers. So the critique is less relevant for mixed tribunals. I will come to ICC because it's my main topic, and as a lawyer, I like to begin with the sources, and I would first analyze with you the statute before entering into a more dynamic discussion. To begin with, let us read the first recital of the preamble. So it's the real beginning of the preamble of the ICC statute, conscious that all peoples are united by common bonds, their cultures pieced together in a shared heritage, and concerned that the delicate mosaic may be shattered at any time, etc., etc. So it's quite poetic. It's not very different from the text of 49, 48, 47, when Universal Declaration, for instance, was drafted. Some observations, or two observations, and I leave the other observation for you. The first sentence of the statute immediately refers to the various cultures. This does not leave room for any doubt about the cultural mission of the ICC. However, it displays a quite conservative approach to culture, as cultures are referring in reality in this text to the heritage. Cultures have delivered an heritage, and the ICC has to protect this heritage. And this approach announces the recognition of destructions of cultural property as crimes against humanity, which is naturally one of the main decisions by the ICC recently. But the living cultures in this first part of the recital are not mentioned. But then comes the second part. The first mission of the ICC is to be a cement of a community and its delicate mosaic, which is under threat of being shattered at any time. This approach is more progressive, and the ICC is entrusted with the role of acting against a threat and preserve not only the heritage, but also the diversity of culture. These are my basic observations. Naturally, you can reflect and perhaps ask questions or comment on the text. Let us continue our route within the construction of the ICC system. And the second step is the construction of crime and the definition of crimes. You could expect, especially after the beginning of the preamble, that the crimes against humanity would be defined, echoing the preamble, with reference to the diversity of humanity. And here I have quoted naturally Hannah Arendt, who is kind of godmother of the notion of crimes against humanity, even if she was not really active in the drafting of the text. And this sentence of the human condition by Arendt, which underlines the link between humanity and plurality. Plurality is a condition of human action. Therefore, humanity, and the value protected by the notion of crimes against humanity, should be defined in relation to diversity and plurality. Let us turn then to one of our basic questions: how to elevate a regional crime to an international crime? The answer may sound simple when these crimes affect values defended by the international legal order. One pre-trial chamber of the ICC has tried to elaborate on this idea, relying on the statute, which in various instances, including Article 53, which I will mention later, legitimizes the competence of an international instance by the gravity of the crime. But gravity doesn't say everything, actually. You have to define what gravity means. And I put the quotation because, unfortunately, it's one of the rare quotations where really the ICC opens a way in our discussion. In assessing the gravity of the crime, due consideration must be given to the social alarm such conduct may have caused to the international community. This criteria of social alarm, in my view, is an important one which allows this elevation of a regional crime to an international crime. And here, naturally, the multicultural challenge appears because you may have different values in the regional and in the international, and how do you manage this clash of values? The third and last dimension of the general debate also starts with the provision of the statute, Article 53, I quoted before, which is a key provision for the functioning of the court as it articulates the criteria which shall govern the prosecutorial activity. Among these criteria, the prosecutor is invited, you have the quotation, to drop an investigation if he or she has substantial reasons to believe that an investigation would not serve the interest of justice. Aware of the importance of this criteria of the interest of justice, the OTP, the Office of the Prosecution, has published in 2007 a policy paper called The Interest of Justice, only on the interest of justice. But I must say, after rereading this paper, which has not been updated, it's disappointing. It's timid and disappointing. Therefore, scholars have tried to go beyond what the prosecution is saying in this paper and what the statute is saying under your eyes, and consider, and I agree with them, that this provision marks a sensible opening up of the definition of the mission of the ICC. The interest of justice, it's interesting, has never been officially invoked by the OTP as the main basis for its decisions. Also, the Office of the Prosecutor always considers this parameter for its deliberations under Article 15 and 53 of the statute. However, when deciding on the Comoros case, which is known at least by the Israelis, I guess, the OTP referred, and the pretrial chamber, when disapproving the position of the OTP of not opening an investigation, referred itself to the interest of justice. Scholars regularly recommend to expand the reference to Article 53, to this part of Article 53, and especially in considering if the prosecution risks being detrimental to the security of affected communities. More broadly, Article 53 allows to take into consideration the effect of prosecutions on the society concerned, and in this way it opens also to transitional justice. Finally, before the conclusion, and as I'm very disciplined because my president is a German, I always say that I have two reasons why I prefer to have a president who is a German. The first, that he's very disciplined, and second, it's the only ones who know how to pronounce Roth. Because if you go to France or if you go to the US, it's very bad for your ears and your ego. So thank you for that. Finally, how do the challenges we have identified as those of multiculturalism reflect on the practice of the institutions? I will give only one illustration because of the time. I will tell you a small series of things about this example. It's letter D. It's a classical question for any criminal lawyer. Shall we take, as a criminal judge, shall we take into account when we qualify actions as crimes or as non-crimes, the individual capacities of the alleged perpetrator? To give an example which has nothing to do with international justice, if a physician in a provincial town makes a mistake which leads to the death of his or her patient, shall we judge this mistake the same way we would judge, appreciate the head of a hospital department in a large city? The question may be transposed to international crimes, but precisely with a multicultural dimension. Shall acts of torture perpetrated by NATO officers be judged according to the same standards as acts of torture perpetrated by warlords in the never-ending conflict in Congo? The question illustrates the tension within the notion of universal justice. Does universal justice mean applying the same standards for every member of the so-called global community, which is referred to in the preamble to the recital, or shall we adopt, or shall the court adopt, what I call the differentialist approach, so different standards for different culture, or the same standard within a universal justice? There is a more political variant to this question, following again the approach by the Twale scholars. Shall you take into account the pre-existing relations of domination when assessing acts of violence? Does a criminal judge in 2018 have to take into consideration and incorporate into his or her judgment the colonial past of countries, assuming, of course, that this past reflects on the personality of the perpetrator. To give a concrete example, not an answer because the answer is left to you. To give a concrete example, the attitude of international tribunals, the Special Court for Sierra Leone and the ICC on the child soldier issue. It had been criticized by anthropologists, and to my opinion, rightly, who pointed out that to begin with, the notion of a child in rural Sierra Leone differs from the Western notion enshrined in international conventions such as the Convention for the Protection of Children. And the judgments of the courts, especially the Special Court for Sierra Leone, did not take enough into consideration, so goes the critic, doesn't take enough into consideration the cultural difference and the way you are handling children in rural Sierra Leone and in Manhattan. Again, the question of universalism versus regionalism. I come to my conclusion, Mr. President, and as any very good conclusion, I recapitulate the introduction, I recapitulate one of the theses, and I bring a new thesis. That's the three parts of any conclusion. So the initial question was how to reconcile the universalist mission of international criminal justice and the recognition of cultural differences in its functioning. I've given, in the brief time I had, some possibilities and some answers. I pointed out on the criteria, and that's naturally derives from the system itself, which is essentially based on the activity of the prosecution. So it's normal within the system to insist on the prosecutorial activity. The criteria guiding the prosecutorial activity can facilitate the integration of regional and cultural differences. We have discussed the interest of justice and the question of gravity and social alarm. The second part of the second thesis of this short conclusion will address briefly, naturally, the question of legitimacy, which is a main question for any institution, but more so for the international institution, and more so again for international criminal justice system institution. This question of legitimacy is multifaceted, and only one facet is relevant here. The US legal scholar David Lubin called, in another context, but called rightly, legitimacy from the bottom. The idea is that taking into account the plurality, taking into account perhaps the history of the society in which crimes occur, would enhance the legitimacy by integrating various cultures. However, the tension between competing legitimate aspirations render universal justice on the one hand and differentiate the context on the other hand, the heritages and the cultures, is and may still remain unresolved. Thank you.
We are like 25 years since the ICC was formed. And you mentioned that the four main nations, or four main forces, are not part of it. Russia, US, India, and China. And because you were so much involved, is there any reason for the ICC still to exist?
I have no doubt that it's a major progress in the evolution of humanity, and there are not so many progresses these last decades. It has a lot of flaws for sure, but it's a complete, in my view, complete mistake to consider the ICC today, for instance, comparing it with, which I hear very often, which is not your point, but with domestic jurisdictions which are more efficient, even perhaps more fair. You are comparing something first which has 400 years, if you consider Germany and or especially the UK and France, which have a system of criminal justice which has developed over 400 years, with something which is developed over 20 years. So you must be an historian, you must have an historic perspective and consider that we will be able to assess the ICC, perhaps not we, our successors in 100 years, not today. Today we have only to work to do it better, to make it better. That's my point, that's my conviction once again. And the fact that this country, which in my view are perhaps not the country with which I sympathize most, including Israel today, I must say, including the US today, for me are not detrimental. I would be puzzled if France or Germany or Australia or the Czech Republic would leave, or Canada would leave the ICC. That it's a kind of work in progress directed by countries we share, and we discussed it during the 2 days, we share values, liberal values. I would not say that the 4 countries you mentioned today share the same liberal values, some of the liberal values, with the countries which are leading the ICC. When these countries which share liberal values, including the aspiration of universal justice, continue their work, one day, perhaps, nobody will know, the other countries which will become more liberal, which will go back to a kind of liberalism, will join too. You have only to work on it, you criticize it, I criticize it a lot. I find the judges are not doing, for instance, a good work in this very tiny part of their work. It's only a tiny part, but I'm critic about this tiny part. I'm also critic about other parts of their work, but we have to work with it. And it's an open discussion. Everybody can publish, everybody can give lectures, everybody can participate in debates. It's a nice experience, and I'm proud personally to participate in this experience.
Question is about differentiation of time with regard to the same crime. Let's take the extreme example. A Nazi German, right after Second World War, and if we judge the same guy today, a guard in a camp or something like that, yeah, which they're doing right now, would you judge that person according to 1940s standards of justice and culturalism, or would you bring him to the 21st century?
I'm more of the sensibility, it's a question of sensibility, of judging the situation, taking into consideration, to a certain point, the situation as it was at the time. Naturally, the Nazis are an extreme example, because nobody would show any tolerance for anything which happened in Germany after 1933. So naturally, you can always say it was part of the German, etc. No way. But where do you put the limit? Because you have other examples which are not so extreme, where really this question can enter into consideration. Dogmatically, but I'm not a dogmatic, even if I belong to the German tradition. But dogmatically, you would answer all these crimes deserve to be international crimes and subject to the jurisdiction of the ICC because they reflect universal and intemporal values. That's the dogmatic answer. So then the answer would be you judge it not as of today, but you judge it regarding or considering the universal mission of this, or the universal definition of these crimes. And that means that you can depart a bit from today's view, but only to the extent that this departing from today's view is compatible with the universal definition of these crimes. That's the dogmatic answer. It's not a pragmatic one. And as a judge, I have always tried, and I've been a judge for 22 years, including 2 in the international criminal justice system, to be pragmatic. I remember when I first began my mission as a judge, an older judge, which had my age today probably, but an older judge came to me and said, because I was a real academic scholar entering into the criminal justice system with a lot of ideas and a lot of sharp opinions, say, my friend, when you issue a decision or a part of the decision which doesn't mean common sense, you have issued a bad decision, which was very good to hear as I was at the time. So you have to be pragmatic, and some pragmatic, so I would say no but more than yes but.
if you're saying that we have to judge a crime according to the local regional culturalism, then by acknowledging certain areas which are less developed more easily, you're deterring them from improving the standards of human rights and taking care of preventing terrorism and torture within their region. Wouldn't you say so?
My view is there is a discretion, there is a space between accepting to put into question the universal value of the prohibition of torture, which naturally is a good example, and applying exactly the same standards to every situation. You can solve it by in the sentencing. You can decide the crimes are the same, there is no difference in the crime, and the difference reflects only in the sentencing. This way, you don't infringe on the general prohibition of torture. It's one of the avenues I will take. But I think there is a space. Again, it's a question of pragmatism. It's also a question of recognition. If I mention these examples where hearing, etc., it's also because the mission of international criminal justice, more than perhaps the mission of other systems of justice, is also a pedagogical mission. If you hear the arguments of the people, it's better than to close your ears to this kind of arguments.